Philadelphia bankruptcy attorney Alfred Abel presents a quick guide to bankruptcies in America. Every year in the U.S., hundreds of thousands of people or more file for bankruptcy as a way of getting out from under debts and other obligations they are unable to pay without assistance. Some of these people are here in Philadelphia and considering obtaining the services of a Philadelphia bankruptcy attorney to help them with their debt restructuring. Bankruptcy can be an extremely complicated undertaking and one which is often misunderstood by the public. Alfred Abel Law Offices offers this short guide covering the most important things people should know about bankruptcy. We can provide a broad overview, but the specifics of every bankruptcy case will vary. The only way to know how your own specific bankruptcy will play out is by consulting with a qualified Philadelphia bankruptcy attorney. What do bankruptcies accomplish? Bankruptcy is a legal tool that fulfills several basic purposes when a person or business has debts or other financial obligations they are unable to meet. Bankruptcy protects the debtor from collections actions and lawsuits from creditors, allows a judge to evaluate the debtor's ability to pay in a structured environment. When possible, creates a plan to pay back some or all debts while forgiving and discharging what cannot be paid back. Provides a fresh start for individuals and a chance for a business to reemerge as a profitable company. Allows individuals to catch up on mortgage or car payments and keep their property. Businesses can reject leases and contracts that are causing losses. In short, bankruptcy allows a person to get back on his or her feet after being in a financially precarious situation. What kind of bankruptcies are there? At present, 6 recognized forms of bankruptcy exist in U.S. courts: Chapters 7, 9, 11, 12, 13, and 15. Chapters 9, 12, and 15 only apply to very specific situations. Most U.S. bankruptcy cases are Chapter 7, 11, or 13. Under Chapter 7 bankruptcy, an individual or family declares an inability to pay, and if the court agrees, the vast majority of the debts are simply discharged by judicial order. In general, the only forms of debts which cannot be discharged under Chapter 7 are student loans, child or family support, tax bills, and criminal fines. Chapter 7 allows an individual to keep some property and other assets up to certain limits. Property above those limits is sold to pay the debts, and creditors often get a small fraction of their debt or nothing at all. Chapter 11 bankruptcy is almost always invoked by businesses rather than individuals. Under Chapter 11, the business continues operation while having its debt restructured, and its revenue is overseen by the court to ensure debts are paid off over time. Chapter 13 bankruptcies are available to both individuals and families, as well as sole proprietor businesses, and involve the creation of a payment plan which is spread out over a period of time up to 5 years. In the event that the debtor fails to uphold the payment plan, they can once again be subject to collections activity or other legal action. Which of your assets are protected? Under Chapter 7 bankruptcy, some property is protected from creditors through exemptions. The court may seize assets that exceed the exemptions and auction them to pay off some of the debt. Exemptions vary from state to state, but in general will include a limited amount of equity in a primary residence, a primary vehicle needed for work or school, possessions required to do work, such as computers or tools of a trade. Paid-in entitlements, such as retirement plans or Social Security. Health aids and medicines. A limited amount of normal household goods and jewelry. The rules governing protected assets are complex, and consultation with a qualified Philadelphia bankruptcy attorney is vital for the most successful bankruptcy case filing. How are bankruptcies resolved? A bankruptcy is resolved once the conditions imposed by the court are met. In the case of Chapter 7 bankruptcies, the time frame could be as little as 3 to 4 months if the debtor has no substantial assets which can be taken as payment. Chapters 11 and 13 involve longer-term payment plans, which can take up to 5 years for a Chapter 13 and longer for a Chapter 11. How is the debtor's credit affected by bankruptcy? Here, distinguishing between bankruptcy and the events leading up to that bankruptcy is important. A bankruptcy will not remove anything from a debtor's credit record. Any missed payments and other negative items will still be on the credit report. Having a bankruptcy on the credit record will also be visible to future creditors and could impact lending decisions. On the other hand, bankruptcy will almost always reduce the amount of debt a debtor is carrying, and this generally improves the credit score. Basically, a bankruptcy will do less harm to a credit record than allowing delinquencies and collections activities to continue unabated. Alfred Abel is a Philadelphia bankruptcy attorney with a long history of serving the local community. Before you commit to any action regarding your finances, schedule a consultation for an analysis of your situation. contact our office at 215-517-8300 or visit www.alfredabellaw.com. To view images used under a Creative Commons license, visit the link below. Thank you for viewing our video. For more information about bankruptcy, be sure to visit our website.